Tara, thanks very much indeed. This is News Talk Lunchtime, Ireland's first national lunchtime news programme. The NTMA's report for 2012 is out. As you heard, Ian Guider, our business editor, is going through that as we speak. And we'll also talk to him about those plans to sell off part of the state's share in Bank of Ireland. What kind of return is that going to be for what the taxpayer did for that bank? Abortion legislation is being talked about in two ways today. There's the ongoing hearing of the Oireachtas Committee on Health that has been listening to legal experts throughout the morning. We'll hear more about that in just a minute. But amid that discussion, we still don't actually have the legislation or the wording of the proposed legislation from government. So how much the hearing that's going on at the moment is going to impact on that wording, I simply don't know. But even before that comes out, we've had the Catholic Church being very vociferous, and one of the things they're most vociferous on is calling for a free vote for members of the Oireachtas on the matter, and that call has been echoed in recent days by the Church of Ireland Gazette. That free vote idea looks like is never going to happen. Here's what Tánaiste Eamon Gilmore had to say, but first, Taoiseach Enda Kenny.
I've already dealt with that matter, and as you know, the Oireachtas Committee are taking hearings on information for the next 3 days.
The government have decided to proceed by legislating and by having regulations. That's a government decision, and all members of the government parties, as is normal, will be expected to support that.
Mary Lou MacDonald of Sinn Féin was on News Talk Breakfast, and she was saying quite plainly that her party is going to enforce the whip on this one as well. So the church is not being listened to on that point, but that is going to make it difficult for some TDs who've already made their feelings known. How many of them are taking part in these 3 days of committee hearings who are going to throw themselves overboard as a result of having to vote with their conscience as opposed to with their party? And what will that mean for those TDs if they get thrown out? How long will they stay on the outside? That's very much a political matter, but what is being discussed at the committee today is how to legislate for this issue, which for so long was ignored by our legislature. 3 legal experts before the committee today. One of those, Dr. Simon Mills, is with us in studio. But first, let's hear a little of what Ciara Staunton from NUI Galway said was her key piece of advice for the legislators as they draw up this bill.
First of all, when this committee begins to draft the heads of the bill, I think the most important thing we do is give effect to the X case. We must ensure that the legislation states when an abortion is lawful in Ireland in accordance with the X case. However, I really would urge you to consider the other issues and the other situations which may arise from Article 43.3. We do not want to come back here again if we can prevent that. The second issue is that the legislation must be prescriptive to a degree to ensure that doctors have certainty as much as they can as to when an abortion is lawful in Ireland. However, the legislation must give effect to the fact that doctors are making hard choices. These are very small number of cases, and the cases and decisions are going to be hard. So we must trust the clinical decisions of our doctors to act in the best interest of both the pregnant woman and the unborn child in accordance with the legislation and Article 43.3. Finally, I just want to reiterate that there should be no floodgates. Suicide is not a catch-all for women who want abortion on demand. A woman is only entitled to an abortion if there's a real and substantial risk to her life, which includes a threat of suicide, and it's only if that suicide is directly linked to her pregnancy. If she's suicidal prior to the pregnancy or just suicidal in general, she will not be entitled to an abortion. It is only when that is very directly linked. Thank you.
Dr. Simon Mills is a barrister and author. He's a former doctor as well. He's with me now in studio and was one of the 3 experts giving evidence and giving testimony to the committee today. Simon Mills, you're welcome to the studio. First of all, we are watching this on television, those of us who aren't there, and it has been quite a measured debate so far. Was that your experience in the chamber?
I think so. In fact, ironically enough, I think perhaps the only person who may have stepped outside the measured debate may have been me, in that perhaps I went a little far in certain sarcastic remarks I made in relation to a question asked by Deputy Flanagan. But aside from that, it is collaborative, it's collegiate, it's a process of careful, thorough and informed inquiry. I was greatly heartened by the depth of consideration that had been given to the matter by the people asking questions, and also greatly heartened by their willingness to listen to responses, even in circumstances where perhaps intuitively or philosophically the people asking the questions were not that receptive to the legal answers being given.
On that point of it being reasonably well informed in the questioning that went there, the point I was trying to make earlier on was that we don't have the wording of this legislation. We're working in somewhat of a vacuum. Somewhere in government it is being drawn up. We don't know what it is. So what is the point of these hearings?
Well, this is something that has arisen ever since the government announced that it was going to, I know capital letters are almost appropriate, do something about this. It has led to, as it were, a rush to the lifeboats by certain people who want to condemn legislation they haven't even seen. And it has also led to the difficult situation which you identify as what is the point of discussing legislative proposals in a vacuum. Which is why, for the purposes of today, I took the perhaps novel step of presenting what I think is workable, succinct, concise draft legislation, which should, I think, form the basis for the kind of terminations of pregnancy which are permissible in accordance with Article 43.3 of the Constitution and in accordance with what the Supreme Court has said about that article.
Talk us through that, because one of the points that was raised by you and by your colleagues inside in the Shannon chamber was that there has to be clarity given to a real and substantial risk to the life of the mother. Is that the central point that arose out of X that needs to be addressed, or is this a more wide-ranging piece of legislation?
Well, I think there are two ways of looking at what is legally permissible. The first is, what do we know? And the second is, what can we reasonably infer? What we know expressly is what the X case said, which is that one of the scenarios in which a termination of pregnancy will be permissible is where there's a real and substantial risk to the life of the mother, including the threat of suicide. That's there. That's the Supreme Court interpreting Article 43.3. Any legislation that doesn't deal with that will, I think, be unconstitutional.
And the problem is that people are already questioning whether that was a valid judgment of the Supreme Court, and it has been raised on this programme by a bishop that the Supreme Court was wrong on that. On a legal basis, there is no justification in saying that.
No, I mean, I put it this way. If they had decided in the opposite direction, and I were to say that I thought that the decision reached by the Supreme Court in the X was the wrong case, a bishop or anybody else from the pro-life side would be very quick to tell me that I was obliged to accept the law of the land. The Supreme Court has spoken on this point, and it remains the law.
So in this legislation that you have drafted, which I think you were discussing with the committee, what is in it? What would happen to a woman who says, I fear for my life?
Well, the first thing to say is that the legislation continues for the time being, into the future, a prohibition on abortion generally, so that it will remain an offence for a person to procure their own abortion or for someone to perform an abortion unless one of the recognised exceptions set out in the bill is satisfied. So what the bill envisages is a number of scenarios where exceptions would be created by the law. To deal with the X case examples, first of all, they include the two scenarios where there's a threat to the life of the mother. The first is arising from some kind of medical circumstances, and the other is arising from the threat of suicide. And in both cases, it would be dealt with in circumstances where registered medical practitioners, to include at least one registered medical practitioner from the specialty concerned, would certify first that there was a real and substantial risk to the life of the mother, and secondly that risk could only be averted by the performance of a termination of pregnancy. In the case of medical scenarios, I would envisage that it would be one consultant obstetrician and one other consultant from a relevant medical specialty, which might be an obstetrician, but it might of course be a non-obstetric medical emergency. And in the other scenario, the threat of suicide, I would envisage that at least one of the doctors concerned would be a consultant psychiatrist. And also, as an additional safeguard, one might consider that assessments of suicidality, having regard to the evidence that was given yesterday by witnesses, might take place on two separate occasions.
This is all in the bill, so you would propose this to be in the legislation, not necessarily in regulations that would follow afterwards. Would that be perhaps a little bit too rigid, as given the nature of medicine? Is that too rigid, or is that arguably too loose? I mean, where's the line drawn?
I think it would be too rigid if it told doctors what decision they should make. All it's doing is saying which doctors should make the decision. And suggesting certain minimum criteria. Now, there are other things that might be included which were adverted to. So Senator Ivana Bacik, for example, talked in one of her questions about an emergency scenario where it's not possible to get 2 doctors. Senator John Crown raised the important point of resourcing issues, where you might have a hospital that only has 1 obstetrician or 1 consultant on duty. What happens there? And these are matters that might need to be addressed, but they're matters of practicality, I think, rather than principle.
You were raising the point as well about the labels that have been put on sides in this debate, the suggestion that people are either pro-life or pro-choice. Is that something you disagree with?
Well, I think there's an unfortunate tendency, and I think, alas, the media has to take some blame for this, which is that in order to have good radio or good copy or good television, there must be an agreement of sufficient quantity as to make interesting listening. And in fact, I think there should be a greater emphasis on the quality of the disagreement. And I think there's just a general tendency to assume that we are divided neatly into pro-life and pro-choice camps. In fact, I think it's a 3-sided debate between those who cleave strongly to pro-life positions, those who cleave strongly to pro-choice positions, and those who adopt moderate positions, starting from either camp but coalescing in the middle. And I think that there's a sufficient caucus, a sufficient constituency of moderate view, such that a bill of the kind that I propose should attract significant support.
Would you fear that the debate as it goes on, when we eventually do get the legislation, when it is being discussed out of the vacuum, that those interest groups on either side of that their voices might be louder than those in the middle, and as a result we end up with the same kind of paralysis we've had for the last 30 years?
But I think the challenge for the media and for our politicians and for all of those in the public forum debating this is not to confuse the volume of the voice with the quality of the argument.
You remember the Law Library now, Simon, but you were a GP for a considerable length of time as well, were you?
That's right, for about 14 years.
Okay, so you would have seen people come through your door. So you're not talking without experience in this. How did you ever encounter pregnant women who said, I may have suicidal tendencies, or is it as rare as was being suggested?
Well, in fact, this question was put to me earlier on by Deputy Naughton. I would have seen a significant but still small number of women who would have been considering terminations of pregnancy. I would also have seen women who were suicidal by reason of depression during pregnancy. But that's a matter that requires expert assessment. And in those cases, I would have referred those women onwards. And the judgment of whether or not they fell into the category of people who were depressed by reason of their pregnancy is a judgment call that was made by people other than me.
Can I just ask one other point before we finish up? Is there an inevitability that whenever this legislation is passed by the Oireachtas, as it will be, that it may end up in the Supreme Court for testing?
Well, it seems probable, I think, that depending on what the contents of the legislation are, if it's a pure X-case piece of legislation, which I think would be foolish. I think this is a chance for the legislation to be proactive and not reactive. But if it's pure X-case legislation, I don't think there would be any purpose to it being referred to the Supreme Court.
It doesn't matter whether there's purpose, but the question is, do you think it'll end up there anyway?
I think a pure X-case legislation is less likely to end up in the Supreme Court. If it goes beyond the X-case, then I think it's probable, not certain, that it may well be referred to the Supreme Court for scrutiny under Article 26. And if that doesn't happen, it may well be that there'll be challenges taken from people with either side views on the question of abortion.
Simon Mills, barrister and one of those taking part in that Oireachtas Committee on Health hearing into abortion legislation. Thanks so much for coming in and talking to us on News Talk Lunchtime. One of the others taking part in that was Jennifer Schwepp. She's a lecturer in constitutional law at University of Limerick. She's been on the programme before. We'll hear from her a little bit later on. But up next, we're going to speak with Dr. Chris Luke, who's a consultant in emergency medicine, about what's going on in our emergency departments around the country when it comes to children who are witnessing some of the worst excesses of humanity, with drunks and drug addicts operating on the same wards.